Before discussing contract law, I will give you a broad explanation of how different areas of law can be slotted and where contract law fits in. There are two broad areas of law, one, public law, and two, private law. Public law deals with the relationships between the state and individuals. There are three bodies of law that fall under public law. The first is constitutional law, which has two main elements. Element 1 deals with the division of powers between the provincial and the federal government. And 2, the Charter of Rights and Freedoms, which outlines the civil and political rights of individuals. Criminal law is the law dealing with the government prosecuting individuals. This is where the government prosecutes an individual for having breached the criminal code. So, for example, if someone robs you and you report it to the police, if the police find the accused and charge her, the proceeding will likely go to court. The proceeding is now between the government, the Crown, and the accused. You have no control over that proceeding, nor are you the one who brings that proceeding against the accused. The last area under public law is administrative law, which deals with the regulatory functions of the state. Because courts cannot deal with every single issue that arises, because there isn't enough manpower in the courts, and there are some issues that require a particular expertise, there are regulatory tribunals that are set up to deal with matters before they get to court. These fall across a broad spectrum and they touch every area of law. So you can have tribunals dealing with labor law. In Canada, we have the Canada Industrial Relations Board. In securities law, so for example, there's the Ontario Securities Commission or the Alberta Securities Commission. Immigration law, there's the Immigration and Refugee Board. There's the Rental Housing Tribunal to deal with landlord and tenant law. And there are many more tribunals. Private law, on the other hand, deals with the relationships between individuals. This is referred to as the law of obligations because it sets out the duties that private individuals owe to each other. The law of obligations has three branches, one of which is contract law. Contract law is the law of agreements and promises. It rests on the basic principle of pacta sunt servanda, which means promises ought to be performed. The objective of contract law is to place the victim of a breach of contract in as good a position as this person would have been in had the contract been performed. This is known as the principle of expectancy. This principle is forward-looking, as in it anticipates the benefit of the promised performance, and it is about voluntarily assumed obligations. Tort law is the law of civil wrongs. It allows for compensation for injuries resulting from wrongful conduct. The objective of tort law is to compensate for the victim's loss, and the principle is backward-looking. It is calculated with the objective of restoring the victim to the place he would have been in had the tort not occurred. Duties arising from tort law are imposed as a matter of law, so these are not voluntarily assumed obligations, unlike contract law. Restitution is where a situation is remedied when someone has been unjustly enriched, as in that person has gained something he or she should not have gained, and it is typically at the expense of another. The objective of restitution is the recovery of benefits unjustly acquired by the defendant. Essentially, it is give me what you gained. So the measure of damages for restitution is the value of the benefit received, as opposed to contract and tort, where the measure of damages is loss by the plaintiff in tort or what the plaintiff would have gotten in contract. So a simple example from your book is that Jill owes $100 to Bob, but through a transfer of funds, she mistakenly pays it to Bill. Bob has been unjustly enriched. Bill has been unjustly enriched, and through the principle of restitution, Bill will have to give Jill back what he gained. This is restitution as a result of mistake. There are other ways to get restitution. We will talk more about restitution throughout the year. These branches of law are the law of obligations. They do not exist in a vacuum, as in they overlap with each other. Some breaches of contract could also be torts. So think about all of them when you're confronting a legal problem. So what is the essence of contract law? First, it is the enforcement of some promises between individuals. Not all promises are enforceable. So, for example, if you make a promise to give a gift, that is not an enforceable promise. The second cornerstone is the fulfillment of reasonable expectations. We noted before that the law of contract aims to place the victim of a breach of contract in as good a position he or she would have been had the contract been performed, which is the principle of expectancy. So, contract law fulfills the expectations that are induced by the conduct of another. When you fulfill reasonable expectations, you are protecting detrimental reliance, meaning someone has reasonably relied on your statements or your conduct, and that reliance has been to their detriment. When we fulfill reasonable expectations, we protect detrimental reliance. What type of law is contract law? Well, there are two types of law in general. First, statutory, and second, judge-made. And contract law, you'll find, is both. So statutory is written down, codified in legislation that is enacted by Parliament. Judge-made law is otherwise known as common law. This is law that has been developed by judges. It is the establishment of legal principles. And what judges do is they apply existing legal principles to each case and build on them as necessary in order for the principle to be applicable to the specific facts of the case before them. And in doing this, judges adhere to the principle of stare decisis, which means they're bound by precedent. All of this means courts are bound to follow prior judicial decisions of courts higher than they are. So once a principle of law has been established with regard to a certain set of facts, future judges are bound to it. Why do we do this? Well, first of all, it ensures there is stability and certainty in the common law. But it also doesn't mean that the law is going to be stagnant. The common law does still develop, even though you have to apply principles that have been determined by judges before you. And the reason that it develops still is because the law must naturally react to new events and ideas. This allows our justice system to respond to society today and not make decisions based on archaic principles of law that have become useless, unnecessary, or unjust. The development also takes place because when judges issue decisions, they do it on the basis of what they understand the law to be. For this, they consider relevant statutes, maybe books and articles, other cases. So two judges looking at the same set of facts may have slightly differing interpretations. This is the evolution and adaptation of law, which takes place exceptionally slowly. There are very few instances of radical changes. Contract law is common law. In Western democracies, the legislator has the power to enact laws to trump the common law, but in Canada, they have largely refrained from doing so. So contract law remains common law. What have been enacted are statutes dealing with particular types of transactions or contracts. So, for example, the Sale of Goods Act, which deals with the sale and purchase of goods. You have legislation dealing with real estate transactions, or employment, or insurance. This is all legislation that specifies the terms that will be included in contracts dealing with those particular transactions, or it deems certain provisions to be included in the absence of provisions to the contrary in the contract. It means that the common law principles governing contract law for the most part remain unchanged and are applied to legislation that deals with certain types of contractual transactions. So for example, assume I make a contract with you to sell you 30 crates of apples. This contract will be covered by the Sale of Goods Act. What does that mean with regard to the interaction between contract common law and the statutory Sale of Goods Act? Well, for a contract to be formed, we need the basic tenets of contract law to be there. We need to make sure that there's offer, acceptance, consideration, intention to create legal relations, and certainty of terms. Once we have those 5 basic elements, a contract has been formed. Now, suppose we have a contract, but also suppose there's nothing in the contract to stipulate the quality of those apples. We didn't include it, maybe for a number of reasons. Maybe we didn't hire lawyers. We may not have thought about this particular element of the agreement. We may have had certain assumptions. So there are many reasons parties do not include terms in a contract. The Sale of Goods Act comes into play when we're dealing with specific provisions. In this case, we didn't include anything in the contract about the quality of apples, but the Sale of Goods Act requires apples to be of merchantable quality. The Sale of Goods Act provisions would not affect the basic tenets of contract law. So you still need the 5 elements of contract law in order for there to be a contract. And there's nothing in the Sale of Goods Act that's going to affect that. If those elements are not there, we don't have a contract to begin with. If those elements are there, the Sale of Goods Act is going to help us interpret and apply our contract. There have been attempts to codify contract law, but they were unsuccessful. Provisions were either too broad and therefore useless, or too specific and therefore inflexible. So contract law largely remains common law, and then there are also a number of statutes that deal with different elements of contracts and different areas of contracts. In this lecture, you should have taken the following. First, you should have a general idea about the 2 areas of law, public and private. And within the area of law, of private law, an understanding of how the law of obligations and its 3 branches are set out. From this, you should have a very general idea about how compensation works in these 3 branches. You should be able to comment on the essence of contract law. We will be getting into the specifics, but you should have an idea of the fact that contract law enforces some provinces made between individuals and protects the reasonable expectations of individuals. You should have a clear understanding of the 2 types of law there are, statutory and common law, and be able to identify where contract law fits in. Now, from what you've learned from this podcast, there are a few questions to think about. Essentially, contract law is about the enforcement of some promises between individuals, thereby protecting the expectations that these individuals have, which would have been induced by others' conduct. From this, you can start to think about certain issues. What kind of promises should the law be able to enforce? What kind of intention or conduct should we need the parties to show before the law will step in? And what should the court be able to do when such a promise is not fulfilled?